Judge DeLay is a friend of mine. First of all, we grew up together. We went to school together at Fort Smith Southside. He is a circuit judge in Fort Smith, Sebastian County, and is running for the Arkansas Supreme Court. It goes without saying, he's got my vote. He's done unbelievable things over his career. In addition to being a fine lawyer, he went on and as I said, is now a circuit judge. Before that, before becoming a circuit judge, he was a Republican state representative and state senator from Fort Smith. One of his quotes in his bio particularly impressed me. It says that the Supreme Court is the last line of defense for protecting the rights of the people. Rights that include free speech, the right to bear arms, and due process of law. That's very important. Today, Judge DeLay is going to speak about the right that we're all here about, and that is the right to know. And with that, I present to you Judge Gunnar DeLay.
Sorry about that. Well, Joey and I have known each other a long time, really even going back to grade school when we competed in boys club athletics. And then, of course, Joey was the quarterback of our football team at Southside. And believe it or not, Joey in high school had this wonderful head of hair. It was just amazing. I was jealous, but the tables have turned. Joey and I are good friends, and as luck would have it, at the current time, we're next door neighbors. And he approached me a couple of weeks ago about if I would be interested in addressing your group. And I said, well, absolutely, because Freedom of Information Act is something that I was passionate about well before I became a judge. I myself, as an attorney, a private attorney, represented an individual on a Freedom of Information Act request. It concerned the Department of Health. That case is probably 30 years old, and it went all the way up to the Arkansas Supreme Court. And we prevailed at the local level. Our local circuit judge agreed with us that we were entitled to those records, and in my opinion, the High Court twisted itself in a knot to figure out a reason why those records should not be disclosed. And the reason is because those records concerned statistics about abortions that were performed in and around our community. So I'm familiar with the Act as an attorney. I'm also familiar with the Act as a legislator, and I'm going to talk a little bit more about that later. But even as a judge, I've only been on the bench since 2018, but I have had a Freedom of Information case that has appeared before our court, and I'll discuss that also here a little bit later. Today I was asked to kind of give a judicial perspective on the Freedom of Information Act. And I think a good place to start in addressing that topic is to kind of give some context about why transparency in government is vitally important to the survival and to the preservation of our representative democracy. And obviously, James Madison has stated it very well here, but it appears that a fact that there's something about human nature that as governments exist, they tend to drift toward elitism, authoritarianism, and what our founding fathers called tyranny. And it really doesn't even matter what form of government you have, whether you're talking about a socialist type form of government or a democracy. It seems over the course of time, they tend to drift toward those things. And so I want you to fully understand what I mean when I talk about elitism or authoritarianism. or aristocracy or tyranny, whatever words you want to use. What I'm talking about is the idea that in a society that there are two sets of rules, one for the governed and one for the governing class. And when that happens, the effect of that is that ultimately that form of government cannot survive, because people ultimately will throw off the yoke of tyranny. And we know that from our own nation's history. If you go open up your history book, that's where the seeds of the American Revolution were sown, in that the colonists were not treated by King George and Parliament the same way as British citizens back on the other side of the Atlantic were being treated. They were really being treated as second-class citizens, and they were being deprived of basic human rights, private property rights, the right to due process in the judicial system. And of course, we know about the taxation without representation. They were being deprived of the right to even protest how they were being treated. So all these things set the table for what really became the American Revolution. And so this is a critical subject when we talk about openness in government, because I'm going to explain why and how that ties in to this historical context. But ultimately, a form of government cannot survive when there are two sets. So let's talk about historically, how did our founding fathers respond to this idea that there were two sets of rules, one for the governed and one for the ruling class? Well, we know they adopted the Declaration of Independence. That's one thing. But after they fought the War of Independence, then they came back together, and they, as a group of men, they said, how do we make sure that this doesn't happen again? How do we form a new government that guarantees that we won't be under that same yoke of tyranny? And so the founding fathers, after they adopted the Constitution, came up with the Bill of Rights. And the Bill of Rights, the whole idea behind that was, we simply want to state what we think is a known and understood fact, that because of we were granted certain rights by our Creator, those rights exist whether they are stated in a document or not. But we're going to put them in our governing document just so people know that we recognize that these are fundamental human rights and they exist and they should not be trampled upon. So the idea was this, that if you want a government that can exist over the course of time, you've got to take that dual form of government and you've got to empower the people. You give power back to the people so that everybody is on the same playing field. That was the idea behind the Bill of Rights. And as you go through each of those 10 amendments, you'll see, oh, that was ceding government back to, or power of government back to the people. And I don't want to go through every single right, but I just want to kind of hit some high points. Let's talk about the First Amendment. The right of free speech is about giving each one of us the right to speak to power. The right of the press gives us the right and authority to publish our thoughts and conscience to power. The right to assemble gives us the right to protest against power. And the right to petition the government gives us the right to complain in person to our governing authorities. And then we know in the Second Amendment, that gave us the individual right that we can protect ourselves without having to ask for the governing power to protect us. The Third Amendment says we've got a right to protect our personal property, even if the ruling elites want to use our farms, our crops, whatever the British Army was doing at that time. They were basically denying the right of personal property ownership. The Fourth Amendment, due process, the right to hearing and a notice of a hearing and an impartial tribunal to guarantee our rights in the judiciary. The Fifth Amendment right of against self-incrimination, that we don't have to can't be compulsed by power to testify against ourselves. The Sixth Amendment, a right to legal representation. You know, those kind of fundamental rights were being denied, that we have the right to help from a skilled attorney if we find ourselves on the other side of power. Of course, I know Joey cares a lot about the Seventh Amendment, but that was huge, because that transferred the right of the judicial system from out of the hands of the crown to the hands of the people, a jury system, fundamental right. The Eighth Amendment was that we have a right to bail, reasonable bail, if we are ever charged with a crime, that we can't be held for months and months and months and months with our liberty being deprived without the ability to get out. And then the Ninth and the Tenth Amendment, which I think were key. And that was a simple reminder that we are a government of enumerated powers, which means that unless a government has been, unless a power was specifically delegated to the federal government, it belongs to the people. So all these things, as you look across those 10 amendments, the whole purpose of that was to level the playing field for the governed in this country. So, as we look around today, do we have elitism? Does it exist? Do we have an aristocracy that exists? I would submit to you that the answer to that question is yes. And who is it? I would say that generally speaking, you could look at the celebrity class. You could certainly look at academia. You could look at the deep state bureaucracy, social media platforms, and unfortunately, all too often, members of the judiciary. They see their primary function as defending the edicts of the ruling class instead of defending the rights of the people that is guaranteed through the Bill of Rights. So yes, it does exist. And now we know, yes, it does present a danger. So how do you address it now? How does that inequity in power get addressed? Because we already have the Bill of Rights. Well, I would submit to you the best way to address it is through transparency in government, through the Freedom of Information Act. Because again, that is a mechanism that levels the playing field, that the governed can now at least get access to information that tells them a lot about the decisions that are being made that affect their lives from the local level all the way up to the federal government. It's key. Although the right to information is not specifically granted in the in the First Amendment, I believe that it is the first cousin of the First Amendment, because there's this inextricable link between the right to speak to power, the right to confront power, the right to challenge power. That all stands on the foundation of being granted the ability to get information to start with about decisions that affect education and our quality of life and in all manners of government. And I think that this dual system that is now percolating in our country was on full display during the COVID crisis, as we had governors at all levels, federal, state, and local level, issuing edicts for the people that they themselves had no intention of living by. Whether that was a travel ban, and yet we would see these mayors or governors traveling about, not going by their own rules. Of course, the mask ban. I mean, which governor from a liberal state didn't have his picture taken somewhere in public where he wasn't going by his, or she going by their own rules? The vaccine mandate, all these different things where the ruling class was pushing it down, but the idea was, well, that's for you folks. That's for you guys, us elitists that run the country, you know, we'll do it as we please. So that's why the Freedom of Information Act is important at all levels of government. And I think you even see that at these confrontations that we see at school board meetings, where parents are shut down, they're silenced, and sometimes even arrested for just trying to speak to power, because they care about their kids and they care about the education and the things that are being presented and discussed and want to know what the agenda is. They're absolutely entitled to that information under any state's freedom of information laws. So, in my experience as an attorney, I mentioned that I have filed a case and I took it all the way to the Supreme Court. One of the things that I took out of that experience is that we know under the Freedom of Information Act that things move along very quickly. You know, they have to respond in a timely, very quick manner. And then if you file a legal challenge, you get into court very quickly, and that case is heard in a short time frame. And that's the way it should be. But the problem comes in if there's an appeal filed. And guess what? There's nothing in the statute or in the court rules that requires a fast-track hearing to this Freedom of Information request. It can languish for months and months and months, and even up to a year before the court finally rules on that appeal. Well, that's what happened in my case. I mean, we got a quick decision, but in my case, we waited this huge amount of time. And I said, you know what? If I ever get elected as a legislator, I'm going to correct that. I'm going to file a bill that amends the act that requires a fast-track hearing on appeals. That's one of the first bills I filed when I got elected as a state legislator. So I went to a hearing to committee, and they said, you know, that may be a good idea, but because of the separation of powers, that's really a matter that has to be addressed by the judiciary, because they make the rules in terms of how they handle appeals and the time frame and all that. So it was shot down, and they said, you know, you need to go address that with the courts. Well, of course, didn't get too far. Well, guess what? I'm running for the Supreme Court. I'll have a seat at the table. I'll be one of the people that now decides those rules. And yes, I'm going to suggest to the rest of the members of the court that it's time that that change be made, because it makes absolutely no sense. The whole legislative intent behind the quick response is that if you want good government, they shouldn't sit on requests indefinitely. We need a prompt response to that information requested. So I'm excited that I could have that opportunity finally to address what would seem like a very common sense approach. In terms of being a judge and having a case involving the Freedom of Information Act, I've only had one of those cases, and it's been in the last year or so that I had that case. I will say that to me, those cases are not incredibly difficult if you're willing to follow the law. I am a strict constructionist, which means that when I interpret statutory language, it's all about following the plain language. And so in that particular case that I was presented, it was very clear that what was being sought was a public record. Our local city said, oh, no. In fact, that records that are being sought, they don't even exist. You know, we can't, it were a series of emails that were presented to Board of Directors group. And it's like, we don't present that, so we're not going to grant that request. The funny thing was, when they put their own IT guy on the stand as their witness, he testified, oh yeah, we can produce those records. I'm like, why are we here? You know, your star witness here that you've called to testify is saying, yeah, we've got them. I can produce them. I can get them this afternoon if you want them. So obviously that was a fairly easy and straightforward a case, and so the plaintiff in that case prevailed, and ultimately those records were provided. But again, there are judges and justices that don't want to follow the plain language of the statute. They think it is their duty as a judge to protect the ruling class. That's why I've been put in place, to make sure that they can decide these matters as they want to. So I think in terms of our responsibility as voters is to make sure that we know what rights we're entitled to under the law, but certainly that we make sure that we elect the right people to the bench that fully respect the laws as they are currently written. Now, one of the problems that we also have is with activist judges. And in that particular case, one of the issues that was brought to the court's attention was that, you know, if a particular record doesn't exist, let's say, for instance, you wanted to know how many times the city has cut the lawn at the city park. How often is that getting done, and how much are we paying for it? Okay, you submit that request. Well, maybe they don't keep records on that kind of thing. Well, that presents an issue because under the statute, there's no compulsion that says they have to respond back and say, you know, Mr. Jones, we don't have that record. We don't keep that kind of record. Instead, they can remain in silence in perpetuity, and the citizen has no idea whether that record exists or not. They have no idea. Are they just not responding to me, or does it exist? And so in that case, it was suggested, well, it's implied that there's a response due. And I said, well, as a strict constructionist, there's no such thing as implied law. It's what's in there. And obviously there's a hole in the law that needs to be addressed, but it needs to be addressed by the legislature. And so there are always things that need to be cleaned up with Freedom of Information Act. And I would submit to you that's one. I would also submit to you that the attorney's fee portion of the statute needs to be cleaned up a little bit. Because there was another Freedom of Information Act that got filed in our court system that was assigned to another judge. And it had to do with the public meeting part of the statute. It wasn't a records request. It was that the city had had an illegal meeting, which is also forbidden by that act. But the way the attorney's fee statute reads now, it says that you basically have to get most of the documents that you've requested in order to be entitled to attorney's fees. And it doesn't really tie into that challenge of a public meeting and whether a meeting should have been public. So again, if I were an activist, I would get with legislative people and say, hey, we need to kind of clean this up, because I think the intent was originally that attorney's fees should be awarded regardless of the nature of the case to the plaintiff if they prevailed. And that includes a challenge to public meetings. So think about all these things, and I think that, again, I hope that I've underscored how important it is to the preservation of our federal government, to the preservation of our state and local government, to have open, transparent government, because once you pull that out of the equation, you're on your road to totalitarianism, authoritarianism, and all those things that are really destructive. So with that, I think that's all my comments this morning. Again, I appreciate the opportunity to address this group, and I wish you all the best. Thank you.